Hello and welcome to this episode on schemes, compromises, arrangements in the New Companies Act 2013. To discuss this very important subject in this episode, we have the benefit of the company of Mr. G.R. Bhatia, who heads the competition law practice in Luthra and Luthra National Law Firm. Mr. Bhatia is also a former officer of the Indian Corporate Law Service. We also have Mr. Lalit Kumar, who is an advocate and a partner in JSA, a national law firm. He's also a company secretary by qualification. Can I begin the discussion by asking you to talk a bit about the most fundamental change that the Act seeks to make, which is the fact that there will now be a tribunal which would look at schemes of arrangement and compromises rather than the High Court uh, in the area where the registered office is.
Right. I think this is the most pertinent question in relation to the new Companies Act which we have in place. Uh, Let me tell you that as I see, company law is a mother corporate law, and all other laws draws inspiration and philosophy from that law. So far as migration of powers from high courts to a specialized body, National Company Law Tribunal is concerned, yes, all the concerns which were raised or which were before the Honorable Supreme Court, as I see, those stand addressed by the formulation or setting up of National Company Law Tribunal, which the law provides
Right,
for.
you're referring to the earlier attempt to make the migration from high courts to a tribunal, which got caught up in a constitutional challenge, and eventually the Supreme Court struck it down with a lot of concerns. All those concerns are now addressed.
Absolutely,
Right.
because now the law provides what shall who shall be a member of the National Company Law Tribunal, what shall be the composition of the National Company Law Tribunal, and who will be what kind of committee and what shall be the composition of the selection committee, who will take a view as to whether a person will be eligible and competent enough to discharge the functions which are going to be entrusted to National Company Law Tribunal under the Companies Act.
Right.
And as I see, we are going to have wide pool of talent in the NCLT, and being a specialized body, as I see that all those functions which will be discharged by National Company Law Tribunal, there will be transparency, there will be swift and efficient disposal of the cases and disputes which are brought before it. Especially so far as mergers are concerned, since NCLT is a specialized body, I see that the the since the rate of disposal, the time span in the having a final approval in relation to mergers, acquisitions, and amalgamations, that will be far less than what it used to be
Right.
taken by the high courts.
Right. So, what makes the tribunal specialized? Can you talk a little bit about the composition of the tribunal, who's eligible, and uh,
Yeah, if you go by section 407 to 427, they relates to uh, about the provisions relates to National Company Law Tribunal, and in the president of the NCLT, if we go by section 407, 408, it provides that who is qualified to be the president and member of a tribunal.
mm,
It says that the president of the NCLT shall be a judge of High Court for 5 years,
at least 5 years
at
standing
least 5 years standing. So it is expected of him to have acquired
experience?
any
Right.
adequate experience,
Judicial experience.
judicial
Yeah.
experience, and the other members can be a judge of a high court or a person who happens to be a district judge for a period of 5 years, or an advocate who has got a standing for over 10 years.
Right.
So, since these people will be coming with judicial experience, with advocate experience,
Mm.
it is expected that
So you have a high court judge, a judicial member, and then a
absolutely,
technical member who comes from a legal background as well.
absolutely, and
Right.
those will be the people who have been administering, implementing the provisions of Companies Act. They will also be
Right.
eligible to become member of the NCLT.
Sure. Sure. Let's move into the area of the scheme itself. Lalit, can you throw some light on what are the salient features, some of the salient features, and Subhatia, please feel free to supplement as well, of the provisions relating to schemes, and how is it that the schemes are envisaged in this act?
Thank you, Som. A couple of changes have been proposed, and one section 230, subsection 4. Very important change with respect to now who can object to the scheme. There's a specific provision which says that at least 10%, a person who holds at least 10% of the shareholding has the right to object to the scheme. Anything less than that does not entitle a person to object to a scheme approved by the majority and other thresholds which are provided. Similarly, for creditors, they've said that a creditor or person holding 5% of the outstanding debt of the company, basis the last audited balance sheet, has a right to object to the scheme. So this is a major change because it will not happen that a shareholder holding 1% or 2% is objecting to the scheme and prevailing over the majority or the wisdom of the majority who has approved the scheme.
Right. So this is an important counterbalance, isn't it? If that serious majority has approved the scheme, can any and every shareholder holding even 1 share or 100 shares object, which was the issue under the old law? Whereas this seems to be counterbalancing and bringing it in line with the oppression mismanagement thresholds, that unless you hold 10%,
Right.
you don't have a voice to object to the majority.
Yeah, absolutely so, because you must have reasonable stake before you object to any kind of contemplated move of the companies.
Right.
And but at the same time, the if you are having less than 10% stake or less than 5% stake so far as total debts of the company are concerned, it's not that the complete window to address your grievances is completely closed. There
Right.
is a provision, adequate safeguards have been inserted in the law to ensure that exit option you can exercise. There is a provision that now there will be a compulsory mandate of having an expert view on the valuation of the shares, etc. And all those things, since exit option is there and then valuation of the shares of minorities have been properly safeguarded, I think they have been taken care of.
Right. So therefore, for availing of the exit option, you don't have to own 10%.
Absolutely,
Right.
yeah,
So
absolutely.
anyone can object.
Anyone can object, even
He'll be
howsoever.
placed on par with any dissentient shareholder, but for his objection to the scheme being approved to have jurisdiction, he has to own 10%.
Absolutely.
That's
Okay,
right.
understood. Any other area of reform that you want to talk
Yeah,
about?
I think one of the requirement which has been placed on the intending merging parties is that they must give an intimation when they issue a notice to the members or creditors. A copy of the notice must be given to the central government and other regulators like Security Exchange Board of India, like Reserve Bank of India, other sectoral regulators including Competition Commission of India. It's a very happy sign because many a times the parties who are going to merge, they either unknowingly or intentionally, they may not inform those concerned regulators. So this gap, I think it has now going to be filled up, and the regulators will come to know what are the mergers which are going to take place in respect of the sectors about which a responsibility devolves on them to regulate. Now, in the case of Competition Commission of India, which is in infancy stage and a new regulator, if an advance intimation is received from a merging party, that's a kind of an advance intimation is given to a Competition Commission of India that to find out, is it that this transaction is reportable, is it that this transaction is notifiable, and has it been notified in time by the intending parties or not. In case delay takes place, certainly the Competition Commission of India can punish the delinquent enterprise.
Right. So if there is a scheme where the parties have not approached the CCI, but CCI gets notification under the Companies Act, it has 30 days to point out to the court that this is a scheme that actually requires my permission and they have not come to me, and therefore this now goes into the 210-day track of CCI having time to review the combination and give its approval. It's not as if 30 days is all that CCI has to consider the entire combination.
No, absolutely, Som, you are absolutely there is clarity what you are saying. The different regulators have been given different timelines to accord approval or to object to an
Right.
proposed mergers. So far as Competition Commission is concerned, as on date, the law provides the maximum time limit is 210 days from the date of filing of a valid notice.
Mm.
So, as the Companies Act now provides for that, in case you are intending to go for mergers or amalgamations, you are mandated to notify. That notice of members is only an intimation to Competition Commission that so and so party is contemplating to go for merger or acquisitions.
Right. Lalit, I'd also like to bring you in here on the SEBI circular, which says that if one of the parties to a scheme is a listed company, then you do a 30-day filing with the stock exchange and then 60 days to SEBI to give its comments, and the comments are to be tabled before the High Court, now the tribunal. So therefore, obviously, those requirements would have to be now aligned with a statutory requirement of 30 days.
That's right. I think that's February circular of SEBI, and it requires what you just said. But here, the notable point is that it says that the regulator will be given 30 days time, and if nothing is heard from the regulator,
Right.
SEBI in your case here is, then it will mean as if they have no representation.
No representation to make, not as if they have approved it.
That's right.
Right.
Specifically, if you distinguish, there's a separate provision for getting no objection or objection to the scheme from the central government. The wording used for central government, it says that if they do not reply or respond in a given time, then in case of central government, it is as if they have no objection.
Right, which is the MCA and the ROC and the
regional
RD and
That's
all
right.
those authorities
That's
under
right.
the Act.
That's right.
Right. Good. So I think this is a very important development then, that statutorily any regulator whose sector is affected by a scheme is put on notice and then has 30 days to react.
That's right.
So it creates two things. A, it creates an obligation to alert, and B, a finite time frame to react.
Absolutely.
Right.
Yeah.
Any other aspects? I was thinking a bit about the accounting treatment, that parties have been writing accounting entries into provisions of schemes of arrangement and saying the High Court has now directed that this shall be the accounting treatment regardless of what the accounting standards are, and that has been addressed in this act. So can you throw some light on that?
Sure. Very important change. Like schemes of amalgamation arrangements have accounting treatment built in the scheme.
Right.
So what it provides is, and accounting standards are written in section 133 as a specific provision. A specific clause is there which says that now the scheme has to conform to the accounting standards, and that certification has to come from company's auditor. So as you said that schemes had accounting standards, some courts insisted that they would not approve the scheme till the auditors give that certificate. But now there's a statutory provision to this effect. An auditor's certificate will be required, and only then the scheme can be filed and scheme has to be supported by that certificate, and the court will not approve. The wording is clear. It says unless it is accompanied, the court will not approve such a scheme. This is, in my view, is one of the major amendments which have
Right.
come.
So the court is obligated to insist on a certification that the accounting standards are complied with.
Absolutely.
I.e., if there is a deviation from accounting standards, the capacity to sanction and approve a scheme has been statutorily taken away.
That's right. You're right here. Yes.
There's one other dimension I'd like to discuss on this episode. While the jurisdiction of the High Court is moved to the tribunal, there's also provision made not to bother the tribunal with schemes of small companies or schemes where it involves a holding company and a wholly owned subsidiary. Can we elaborate on what exactly has been done here?
Yeah, absolutely. You are right, Som. There is a specific provision in the law that in case the merger is qua small companies, or if the merger is between a holding and a wholly owned subsidiary company, then in that event they need not knock at the door of the NCLT for approval.
That what would be a small company?
Yeah, small company is one that is also defined in the law. A small company is one whose paid up capital doesn't exceed 50 lakh rupees, or the turnover of the enterprise doesn't exceed more than 2 crore rupees. These conditions are uh, not cumulative, it is either or. So
Right.
if you fall in any of the category, then you are labeled as a small company, and in the event that you are a small companies and merger takes place, then you need not knock at the door of the
Tribunal.
NCLT. The prescribed procedure has been prescribed, has been laid down in the law. You have to give notice of that proposed merger. Then registrar of companies and etc., they have to give their objections or suggestions if any, and post consideration, and these will be considered by the central government, and the central government normally it is expected to accord approval unless the central government is of the view that the proposed merger is not in public interest, or that it is going to affect in any other manner. Only in that event the central government will become a referee, and they will make a reference to the NCLT for such action as NCLT may deem appropriate.
Right. So here the central government plays the role that would otherwise be played by the tribunal.
Absolutely.
The objections.
In the event that the central government doesn't see any objection to the proposed merger, it will accord approval, and so it will be, since it will be an executive action, and in case the central government is of the opinion that there is larger public interest involved and there are some issues in before according approval, then the matter will be adjudicated by the National Company Law Tribunal.
Right.
And for your let me also tell you that under the competition law also, there certain exemptions have been carved out. Like if it is not that all mergers are required to be reported.
Sure, unless the thresholds are met,
Absolutely.
you don't need to
And
go to
similar
the.
is the situation of
Right.
if there is a merger between holding and a wholly owned subsidiary company, no approval is required, uh, even if the threshold crosses
Right.
under the Competition Act
Because in
also.
any case it's under the same control.
Absolutely.
Right. So Lalit, do you want to supplement any of this issue?
I think additionally, there are two requirements here when you go in a merger of a two or more small companies or holding an wholly owned subsidiary company. The threshold for approval has been increased. So it will be 90% of the members and 90% of the creditors have to approve the scheme,
Right.
not the normal which is required at the level of 75% for other
Right.
schemes. And there's another important aspect is that each company involved has to also file and certify by way of a declaration of solvency, which will mean that the companies are solvent, and it's not because they are insolvent or going to get insolvent, hence they have taken this route of merger or amalgamation. So I'll just like to add there.
Right. So these have to be small companies or a holding company and subsidiary relationship. 90% of the shareholders and 90% of the creditors should be saying they have no problem with the scheme.
That's right.
And in these cases, you do not need to bother the tribunal. The central government has the power to approve.
Right.
If over and above all this, there are objections from the registrar or the official liquidator, and there are issues that the central government thinks arise that impact public interest or the interests of creditors, it can refer the file to the tribunal, in which case the tribunal will adjudicate on the issues. So the power to say no is with the tribunal,
That's
the
right.
power to say yes is with the central government.
That would
Absolutely.
be right to say. Yes.
Okay. So should we talk about any other aspect of uh, this chapter on schemes and compromises?
Important change with respect to exit to dissenting shareholders.
Right.
So section 230 subsection 7 gives power to the tribunal to pass certain orders. One of the powers given to the tribunal is they can, as a part of the scheme, provide for exit offers to the shareholders who are dissenting. and the scheme will provide for those provisions. And because the scheme will be approved by the shareholders and creditors, so whatever are the terms and condition of such exit, they are provided in the scheme.
So the
That's one.
scheme is required to provide for it.
No, not necessary, but
Right.
if the
It may provide.
it may provide for it, that if there is a situation where the terms of the scheme are such that the exiting shareholders or dissenting shareholders are needed to opt out, then the company has to provide how will those shareholders be dealt, how will the exit be dealt, and provide it in the scheme. And when it becomes a part of the scheme, the tribunal will see and can pass necessary orders. So one of the things provided in the powers to pass that order in section 230 subsection 7, this power is also given to tribunal. There's another interesting aspect which is in section 232, in situations where a listed company merges with an unlisted company. So where the transferee company is unlisted company and the transferee company is not intending to get listed. In that situation also, there is a provision that shareholders who do not want to be part of that transfer company's shareholders who do not want to be with the unlisted company, they have to be given an option to exit. And that option has to be at a predetermined valuation, so that if they are not fine with remaining as shareholder of unlisted company because they were shareholders of listed company, they should be given that exit. So these are important provisions which have come. In fact, this section 235 also details some other provisions of providing exit to the dissenting shareholders. So I would say this is another area which has changed in the schemes of arrangement and amalgamations under section 213, chapter 15.
Right. Is there any other procedural or operational part of this chapter 15 that you'd like to highlight?
The disclosure norms and disclosure requirements have been enhanced as compared to what we have under the Companies Act 1956. So certain disclosures are with respect to now the material facts relating to the company, the financial position of the company, audit report, any pending litigation, investigation against the company. Then is there any scheme or compromise with respect to reduction of share capital? Has the company undergone any scheme of CDR, which is consented by at least 75% of the secured creditors? Has to be disclosed. Valuation report, copy of the valuation report has to go with the notice. Then there are additional requirements with respect to explaining the effect of compromise or arrangement on creditors, KMPs, promoters and non-promoter members. And this is in the part of the board report. The important point here is that the board has to explain in the report the effects of the scheme and compromise and arrangement. Other important thing in my view is now notice of the members meeting, creditors meeting, which go to the members and creditors, have to also put on company's website. So all in all, what has happened is that the disclosure standards and norms have increased, which will give better position and picture to the shareholders and creditors when they are approving the scheme. So I think this will go on a long way to help the shareholders and members decide whether the scheme is in the interest or not before they approve it.
Okay. Mr. Bhatia?
Yeah, I see that there is twin provisions which further simplify and rationalize the process of mergers and acquisitions are one, that the NCLT has been empowered to dispense with the requirement of sending notice, etc., if an affidavit is filed by 95% of the creditors that they agree with the scheme of compromise. And another
Which high courts used to do by discretion
by
for
discretion
court earlier.
absolutely. So now NCLT has been statutorily provided, and hopefully that it will be abided because it is in the interest of the parties for quick and swift approval. Another I think distinct feature which has been introduced is that in order to have larger participation of the people, postal mode has also been accepted as a mode of voting for the scheme of compromise and arrangements. These two things are going to further.
So when you say things have been rationalized and expedited, these surely go towards
in that direction,
achieving that.
Yeah.
So should we summarize with on this episode, what would be in your view, in each of your views, for a couple of minutes, What are the key highlights and takeaways in this area of law?
Yeah, as I see, I think the process of considering and according approval for mergers from the competition law perspective, those provisions have been rationalized. The migration of power from High Court to NCLT is a welcome step, and it is expected that the henceforth the mergers and acquisitions will be accorded, considered efficiently, speedily, and the corporate sector have the benefit of swift approvals from the NCLT.
Right. Well,
I would also just like to add here, there's an important provision in section 234 which also allows now Indian companies can merge with a foreign company. That would encourage cross-border. The other way around is permitted even under the Companies Act 1956, but Indian companies were not permitted to merge with foreign companies. But that comes with certain conditions. One is it has to be as per the RBI
yes,
regulations, which
exchange controls will
exchange
apply.
control
It
regulation.
acknowledges now that the Companies Act won't stand in the way.
That's right.
Right.
That's right. And with companies which are in territories which the central government will notify.
Right.
It is not that all the countries will be notified for this cross-border merger. So that's an important aspect. But
That's more
overall,
from a money laundering FATF point.
that's right. That's right. And so overall, I think this is the many provisions which have come. Some would be also making in a time-bound manner certain internal corporate restructuring, as we discussed, small companies, wholly owned subsidiaries with holding company merger, and exit options, and one provision of minority squeeze out, but it's really not a squeeze out. It says purchase of minority shareholding, this section 236, in situations where the acquirer or a person acting with the acquirer has acquired 90%. That acquirer is under an obligation to give an offer to the remaining 10% shareholders if they want to sell their shares. It's not really a compulsory
So it's
squeeze
an
out.
offer, it's not a squeeze out.
Really, it's not a squeeze out. And similarly, the minority shareholders can themselves offer their shares to an acquirer who has acquired 90% and more. In that situation, the acquirer is bound to buy from the minority shareholder if the offer comes from the minority shareholder.
And surely in the case of a listed company, it'll also have to comply with the delisting requirements of the SEBI regulations.
That's right. And a specific section has been, subsection has been inserted to deal with
To
that
say that,
situation. So, yes.
Good. Thank you. Thanks a lot for participating in this episode. That's all we have time for on this very important subject of schemes of arrangement, compromises, mergers. Thank you very much. We encourage the viewers to actually pick up the provisions and read them. This video is only aimed at being a overriding primer on some of the key highlights. Do read the provisions. Thank you for watching. Hello and welcome to this episode on schemes, compromises, arrangements in the new Companies Act 2013. To discuss this very important subject in this episode, we have the benefit of the company of Mr. G.R. Bhatia, who heads the competition law practice in Luthra and Luthra national law firm. Mr. Bhatia is also a former officer of the Indian Corporate Law Service. We also have Mr. Lalit Kumar, who is an advocate and a partner in JSA, a national law firm. He's also a company secretary by qualification. Can I begin the discussion by asking you to talk a bit about the most fundamental change that the Act seeks to make, which is the fact that there will now be a tribunal which would look at schemes of arrangement and compromises rather than the High Court in the area where the registered office is.
formulation or setting up of national company law tribunal, which the law provides
Right.
for.
You're referring to the earlier attempt to make the migration from high courts to a tribunal, which got caught up in a constitutional challenge, and eventually the Supreme Court struck it down with a lot of concerns. All those concerns are now addressed.
Absolutely,
Right.
because now the law provides what shall who shall be a member of the National Company Law Tribunal, what shall be the composition of the National Company Law Tribunal, and who will be what kind of committee and what shall be the composition of the selection committee, who will take a view as to whether a person will be right. I think this is the most pertinent question in relation to the new Companies Act which we have in place. Uh, Let me tell you that as I see, company law is a mother corporate law, and all other laws draws inspiration and philosophy from that law. So far as migration of powers from high courts to a specialized body, National Company Law Tribunal is concerned, yes, all the concerns which were raised or which were before the Honorable Supreme Court, as I see, those stand addressed by eligible and competent enough to discharge the functions which are going to be entrusted to National Company Law Tribunal under the Companies Act.
Right.
And as I see, we are going to have wide pool of talent in the NCLT, and being a specialized body, as I see that all those functions which will be discharged by National Company Law Tribunal, there will be transparency, there will be swift and efficient disposal of the cases and disputes which are brought before it. Especially so far as mergers are concerned, since NCLT is a specialized body, I see that the the since the rate of disposal, the time span in the